Hi, good evening everyone, and welcome to Guardian Court Chambers Housing Team's first webinar of 2021. It's really nice to see so many friends and colleagues here in the participants list. And just before I introduce our speakers, a couple of quick technical things. You've all been placed on mute, so please do put your questions to the panelists in the Q&A function below, and I'll be looking at those and putting them to the speakers after their talks. We've also got the chat function enabled, so if you've got any comments during or after the presentations, then please do put them in the chat. We will be sending round these slides and possibly a recording after the webinar. It's being recorded, and what that means is the audio and video of anyone who speaks will be recorded. So if you're unmuted, that will be recorded. And if you've got any difficulties, I think we've just put some instructions in the chat function now. So either have a look at those or put any queries in the chat if anything comes up. So we're looking at discrimination and housing this evening, and we've got two brilliant speakers. First to speak, we'll have Tessa Buchanan, who was recently instructed in a case about discrimination in the private rented sector, which I'm sure she'll tell you about. And she's also been involved in several very interesting cases where private landlords have fallen foul of anti-discrimination law. And then we'll hear from Ed Fitzpatrick, who's going to be looking at the public sector equality duty in homelessness cases, and also at some of the interesting practical, legal and procedural points that tend to arise when we have clients who are under a disability or other protected characteristics. And before I pass over to them, as I said a minute ago, this is our first of the 2021 programme. So just a date for your diary. Our next webinar is the 6th of March, and it'll be looking at eligibility after Brexit. So without further ado, I'll pass to Tessa.
Great, thank you very much, Nick. Hello, everybody. So I'm just going to share my screen, which will hopefully go without incident. Okay, so you should hopefully be seeing the first slide, which is just the Garden Court logo. If you're seeing something else, let me know. So as Nick said, I'm going to be talking about the recent no DSS cases, as they're commonly known, and the use of the Equality Act in challenging particular types of what we would say are discrimination in the private rented sector. These cases are hopefully of some interest because the no DSS policies are or have been incredibly widespread in the private rented sector, and hopefully also this might be something of an encouraging example of how the Equality Act can be used in practice. So firstly, what do we mean by no DSS? It's a phrase which you've probably heard sort of 100 times, whether sort of just in the background when you yourself are looking through estate agent adverts, or perhaps in more recent coverage. And I'm sure most of you will have a fairly good grasp of what it means. But just sort of so we're all on the same page, what I'm talking about when I say no DSS is the terminology used to indicate to an applicant that if you're on benefits, then you're not going to be accepted. And it could be any benefits, or it could be just means-tested benefits, or it could be just housing benefit. And often it's not really a deeply well thought out policy. It's just a no benefits rule. And this could be something that is adopted by an individual landlord, or it could be adopted by the landlord on the advice of the letting agent, or both. And again, it could be something which is a company-wide policy adopted by a whole estate agency, or just one landlord with one property. So it can manifest itself in a wide variety of ways. And no DSS is obviously shorthand, and I use it here as shorthand. It's not in itself a magic formula. And what that means is that what's important is what it means and what it evokes, and not the words themselves. So sometimes I've seen it suggested that, well, we'll just remove the words no DSS and then that'll be fine. And I would suggest that that probably won't be fine, because the question is, are people being rejected because they're on benefits? If so, then whatever you call it, it's the no DSS policy. So it's a substance, not the form. And the impact of this is pretty obvious, really. It's that people are being rejected, not because of some problem with their individual circumstances, but simply because of the fact that they rely on the state for a part or whole of their income. And it's something that could be a formal written policy, or it's just an informal policy, or it's even communicated verbally over the phone to someone, or sometimes it's a little more obvious, as this example shows. My favourite thing about this photo is the little asterisk in the corner saying sorry for any inconvenience, which obviously makes it all okay. The scale of no DSS is fairly stark. It's widespread, and it has been widespread for a long time. I've put some statistics there which kind of give a flavour of what we're talking about. So between 2003 and 2005, 13,000 private rented sector adverts were looked at, of which a third barred housing benefit claimants. And then when inquiries were made of the remainder, only a sixth of those said that they would accept such a tenant. So you can imagine from that what sort of proportion of the market is available to people on benefits. And that's something that's a picture which has carried on more or less, almost really to the present day. So 2013, 78% of 1,000 landlords surveyed said they weren't willing to accept such tenants. 2014, 52% of members of the National Landlords Association said that. And even 2019 to 20, 41% of landlords surveyed said they had an outright bar. So it's perhaps going down a bit, but it's certainly not an issue that's gone away. And one point on this is that I think for some people, the fact that it's widespread sort of feels like it should be a defence because everyone else is doing it. But we would say it's not. If it's discriminatory, then the fact that everyone else is being discriminatory doesn't help it and could even be an exacerbating factor. So that's broadly what I'm talking about. And the way that these policies have been challenged is under the Equality Act, which is something that you will all be familiar with, I'm sure. One response which is sometimes given to the argument that these policies are not lawful is, well, there's no law against it. And obviously, there isn't a law that says you shall not have a no DSS policy. But that doesn't mean it's lawful, because if it's contrary to something else, and we would say the Equality Act, then it's not allowed. So I'm just going to briefly kind of give an overview of the Equality Act because it's relevant both to what I'll be discussing and to what Ed will be discussing. Apologies to those for whom this is all very obvious, but I think it might help to kind of highlight the relevant parts that we'll be focusing in on. So in terms of a very broad overview, the Equality Act, which came into force in October 2010, so it's recently had its 10-year anniversary, essentially makes certain unfavourable treatment in respect of certain protected characteristics unlawful. So where people have certain features or characteristics, then there are certain ways of treating them are not allowed. The characteristics are in Chapter 1 of Part 2, the types of unfavourable treatment in Chapter 2, Part 2, and then the circumstances in which that treatment will be unlawful are in Parts 3 to 7, and then enforcement action in Part 9. The protected characteristics, again, are well known: age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex and sexual orientation. The most relevant ones for our purposes in terms of what I'll be discussing are disability and sex, and I'll come to those in more detail later. But one observation is that not all the protected characteristics apply or are relevant for all purposes. So some types of discrimination can only be committed in respect of certain protected characteristics. The unfavourable treatment is essentially made up of 4 types of treatment. Firstly, and most relevant for our purposes, is discrimination. That's at sections 13 to 19. But then we also have a failure to make reasonable adjustments for somebody who's disabled, and harassment and victimisation. As I said, it's discrimination which is most relevant for what I'll be discussing. And there are two broad types of discrimination, which are direct and indirect. So direct discrimination, which is defined in section 13, occurs when a person it will exist when a person discriminates against another if, because of a protected characteristic, A treats B less favourably than A treats or would treat others. So in short, it's when somebody treats someone less well, unfavourably, because of their protected characteristic. So, for example, if someone is refused entry to a bar because of their race, then that would be direct discrimination. And one response which we quite often hear in these types of challenges is, well, yes, I said that I wouldn't accept them because they're on benefits, but that had nothing to do with them being a woman or them being disabled. I didn't even know they were a woman or disabled. But that just means, or may mean, that it's not direct discrimination. It doesn't mean that it's not indirectly discriminatory. And it's the indirect discrimination under which the cases to date have been brought. So the basic definition is at section 19, a person A discriminates against another B if A applies to B a provision, criterion, or practice which is discriminatory in relation to a relevant protected characteristic of B's. So essentially, if you have a policy which puts certain people with particular characteristics at a special disadvantage, then you may be looking at indirect discrimination. So by way of a pretty sort of simple example, if you have a rule that says no women are allowed into this restaurant, then you'd be looking at direct discrimination. If you have a rule that says nobody under 5'8" can come into the restaurant, then you may well be looking at indirect discrimination because women are likely to be shorter than men and therefore more likely to be caught by such a rule. So indirect discrimination is spelt out in section 19.2, and that breaks down, as you can see, into a number of different requirements. Firstly, there has to be a provision, criterion, or practice. Secondly, B, who is the claimant usually, has to have a protected characteristic. Then this provision, criterion, or practice, or PCP for short, has to apply to people who don't have that protected characteristic. So it's of prima facie neutral application. Then the question is, does the PCP put, or would it put, people with whom B shares their protected characteristic, so women or disabled people, at a particular disadvantage when compared to people who don't share that protected characteristic? And then does it actually put B at that disadvantage? And finally, is it not a proportionate means of achieving a legitimate aim? And then the legislation, the Equality Act, goes on to say where that discrimination occurs, then in certain circumstances that will be unlawful. So we have the definitions in the provisions that I've just looked at, and then we have the provisions which actually make that discrimination unlawful. And the two which are most relevant for the sake of these cases are firstly section 29, which deals with the provision of services to the public, and it states that a person, a service provider concerned with the provision of a service to the public or a section of the public, for payment or not, must not discriminate against a person requiring the service by not providing the person with the service. So that means what it says, you can't discriminate when you're providing services to the public. And then section 33, the disposal of premises. So a person who has the right to dispose of premises must not discriminate against another as to the terms on which the person offers to dispose of the premises, or by not disposing of the premises to the particular person, or in their treatment of this person with respect to things done in relation to persons seeking premises. And you can see why these provisions are likely to be relevant. Lettings agents are generally providing services to the public, they're facilitating the letting of property, and landlords are generally disposing of premises. And of course, you may get landlords who are also providing services to the public, and you may get agents who have the authority to dispose of premises. But essentially, it means that if you're in the business of letting, you can't discriminate. If you do have a claim for discrimination, then your route, at least in relation to these types of claims, is to bring a case in the county court. You've got 6 months to do that, although that deadline can be extended if it's just and equitable to do so. And if you succeed, then the county court can award any remedy which could be granted by the High Court in a claim for JR or for tort. That will include a declaration and damages. And in terms of the burden of proof, there is provision for that at section 136, which states that if there are facts from which the court could decide, in the absence of other explanation, that the person contravened the provision of the Equality Act, then the court must hold that the contravention occurred, but it doesn't apply if the defendant can show that they didn't contravene the provision. So essentially it means if you have a prima facie case of discrimination, then the burden of proof is reversed in broad terms. So that's a kind of whistle-stop tour of the Equality Act. Applying that then to cases alleging no DSS policies and discrimination under those. So how does the Equality Act relate to that, and why do we say that the Equality Act makes such policies unlawful? So if we just think back to that test for indirect discrimination at section 19.2, as I said, that kind of breaks down into a number of criteria or requirements, and looking at those in turn and applying them to the context of no DSS policies. The first question is going to be, does the defendant have a PCP, a provision, criterion, or practice of not accepting applicants in receipt of benefits? And this is often the sort of most fiercely fought over battleground. It's often denied that such a PCP exists. There are a few kind of relevant or helpful points to note in relation to the existence of a PCP. Firstly, we know that it's something which should be widely construed. It's not limited to formal minuted policies. It doesn't have to be written down. It doesn't need to be of absolutely universal application. And it can, although it won't necessarily include even one-off decisions, if there's sufficient sort of continuity and a likelihood that that is how other similar cases would have been treated. It's almost always a question of fact as to whether a PCP exists, but just taking a sort of standoff view, if the position is someone on benefits isn't accepted, then it's likely to amount to a PCP, even, as I think I said, even if it's just one landlord or even one property. Then, does the claimant have a protected characteristic? I mentioned earlier that the most relevant are, or at least have been to date, disability and sex. So with disability, this is defined as a physical or mental impairment which has a substantial and long-term adverse effect on the person's ability to carry out normal day-to-day activities. That is, of course, further defined in more details in both the schedule to the Equality Act and in regulations. But we know that an impairment will be long-term if it's lasted or is likely to last at least 12 months. And of course, there are other provisions in relation to the effect of medication being discounted or certain conditions that are deemed to amount to a disability. But what doesn't need to exist is prior knowledge on behalf of the landlord. So because we're not looking at disability discrimination, we're looking at indirect discrimination. It's not relevant that the landlord knew whether or not they knew in advance that the claimant had disability, or rather I should say it's not necessary. It may be relevant in terms of damages potentially, but it's not a necessary criterion. Sex is defined as being a man or a woman. I know that many of us would sort of have questions about that, but that's what the Equality Act says it is to be understood as. It's possible that other protected characteristics will be relevant. The question is essentially, are people with a particular characteristic more likely than people without that characteristic to claim benefits, to claim housing benefits? So if, for example, there is data showing that people of a particular sexual orientation are more likely to claim housing benefit, then that might also found a claim for indirect discrimination. But these are the ones that have been looked at to date most closely. So PCP, protected characteristic, and then we have the question, does the PCP apply to people without that protected characteristic? Because indirect discrimination occurs when the PCP is of at least a sensibly neutral application. It's not usually controversial because people don't usually want to assert that their PCP only applies to women. That's not a very attractive position to put forward, and it's not usually the case either. But it's also important to note that it's not a defence. This is what makes it indirect discrimination as opposed to direct discrimination. So saying we reject everyone on benefits, it's not just women, is what makes it a claim under Section 19. It's not a defence to a claim under Section 19. The next question, in some ways the most meaty one, at least in terms of data, is does the PCP put people with whom the claimant shares a protected characteristic at a particular disadvantage? So the key question is, does a no DSS PCP affect a particular group of people, such as women or people with disabilities, more than it affects people without that characteristic, such as men, people without disabilities? We've got a fairly recent Supreme Court case which looked closely at the nature of indirect discrimination and provided some really helpful points as to what you need and what you don't need in order to have a successful claim. One thing that we don't need is an explanation as to why the group of people, such as women, is put at the disadvantage. So we do need the group advantage. That's kind of what makes it indirect discrimination. But we don't need to say, why is it that this particular group are disadvantaged by such a PCP? So earlier on, I gave the example of a rule of people being under 5'8", not allowed into a restaurant. Now, it's kind of obvious why that may well put women at a disadvantage, because women are shorter, but we don't need to show that causal link. And in ESSEP, one of the cases that the court was considering was that civil servants of particular ethnic backgrounds were less likely to pass a test which was necessary for promotion. And there was no reason that the Supreme Court knew as to why that was the case, but it didn't matter. That wasn't essential. And so we don't need to say why women or disabled people are put at a particular disadvantage by a no benefits rule. Although, again, I think it's probably fairly obvious as to why such people might not be able to work so easily because of the challenges arising from their disabilities, or because perhaps of caring responsibilities. There is no need for a causal link between the characteristic and the particular disadvantage. So it's a similar, but it's not quite the same point. There's no need to show that the disadvantage arises because of being a woman or being disabled. And again, that kind of makes sense, because otherwise you would sort of start to encroach upon direct discrimination. It doesn't need to be the case, and it probably isn't usually the case, that every member of the group is put at the disadvantage. So you don't need to show that all women claim housing benefit and would therefore be disadvantaged by a no DSS policy, or that all disabled people would do that. The question is, do a larger proportion of that group do that, i.e. claim benefits, and then of other groups? And again, if it was the case that everybody in the group was subject to the disadvantage, then you'd probably be looking closely at direct discrimination as opposed to indirect. And finally, it's very common for the disadvantage to be demonstrated with statistical evidence, which is how it's been approached in the current cases. So Shelter have done lots of research into whether certain groups of people are more likely to claim housing-related benefits than other groups of people. And what their research has shown, as has been put forward, is that the answer is yes, certain groups are more likely to claim it. So as I've said, disability and sex are the most relevant characteristics for these purposes. In relation to disability, research showed that disabled households in the private rented sector are almost 3 times more likely to claim housing benefit than non-disabled households. And disabled households in the population generally are almost 5 times more likely to claim it. So those are some really quite stark figures as to the disproportionate effect of such a policy on disabled people. And then in relation to sex, women in the private rented sector are more than 1.5 times as likely as men to claim housing benefit. And that's really the heart of the case in many ways. women are more likely to claim housing benefit than men. Disabled people are more likely to claim housing benefit than non-disabled people. And as a result, if you have a rule that says no benefits, then you're going to be putting women and disabled people at a particular disadvantage. And I think sometimes sort of viewed through that lens, the reason why it sort of is unfair becomes obvious. And as I said before, it doesn't matter that some women don't claim housing benefit, and equally it doesn't matter that some men do claim housing benefit. The question is the group proportionately disadvantaged? The next question is a factual one. Was the claimant put at that disadvantage, or would he or she have been put at that disadvantage? And as the quote on the slide there makes clear, you can have indirect discrimination even where someone is just deterred from doing something. So it's not actually necessary that the claimant approaches the door of the restaurant and asks to go in if they know about the policy and are put off from going when otherwise they would have liked to have gone, then that can be enough. This question is usually, it's coterminous usually with whether or not the PCP actually exists, because the two are often bound up together. But as I've said, it's generally a question of evidence as to what happened to the claimant in that particular case. Then if those criteria are all established, we move on to the question of justification. So it is open to a defendant who has a policy which is indirectly discriminatory to nevertheless justify that policy on the grounds that it is a proportionate means of achieving a legitimate aim. And if they can do that, then it won't be unlawful. Some people refer to it being potentially discriminatory, and then if it is not justified, it is discriminatory. Or some people refer to it being discriminatory, and then the question is whether or not it's lawful or unlawfully discriminatory. But the key point is that it can be justified. The burden, of course, is on the defendant, so the estate agent or the landlord, to justify the policy. And it's a question on which the court will reach its own judgment. It's not like a JR, where there's a range of reasonable responses open to the defendant. There isn't a margin of discretion in that way. The court will decide whether or not this is justified. And it's fairly obvious that the more serious the disadvantage, the more compelling the justification will have to be. We know that wanting to save costs isn't on its own going to be sufficient justification. There's been some recent case law on this, that's put on the slide, which has essentially held that a desire to save costs isn't sufficient, although it may be sufficient if it's coupled with another factor, but a need to reduce costs can be. So that's quite a fine distinction, and I'm sure will give rise to a lot of argument. But I think that the point does remain that simply wishing to save money isn't going to be enough. The responses that are often raised in relation to no DSS policies as to reasons why it's justified, or things that are seen in the literature, are things like the rent won't be paid, or I can't, it's against my mortgage, or my insurance doesn't cover it. And again, Shelter's looked into these and is satisfied that they don't really provide substantive justification. The evidence that we've looked at doesn't show that housing benefit claimants are a sort of significant financial risk. There was a survey which showed that landlords letting to such claimants are no less likely to be profitable than the average. And it's important to note here that nobody's saying you have to give someone a tenancy even though they clearly can't afford it. The issue is simply you cannot assume that somebody can't afford it simply because of the source of their income. So it's about looking at everybody on their own merits. And many housing benefit tenants are in part-time work, or they have a guarantor or saving. So it's not fair or safe to simply say you're on benefits, therefore you can't pay the rent. As to the mortgage, by all means, of course, check the mortgage conditions, but it's very unlikely that that will actually be an issue, because by now, the vast majority of lenders don't have such a term in their mortgage contracts, and that's largely part to due to really some fantastic campaigning work by Shelter. But even if they did have it, there would be an argument that that wouldn't be enough to justify the discrimination because of Section 142 of the Equality Act, which says that a term of a contract is unenforceable if it is contrary to the Equality Act. And the similar issue may apply in relation to insurance, if it exists, which is by no means necessarily the case, because actually only a fairly small proportion of landlords have insurance. But even if it does, then again, Section 142 may mean that it's not a defence. So turning to no DSS in the courts, the cases have been coming before the courts, and I'm going to go through them now and show sort of what's been the outcomes. So I've said firstly Jane and a letting agent, but really I should mention firstly the case of Rosie Keogh, who is an incredible woman who brought a claim, I think back in 2016, so a few years ago now, alleging that having been refused on the basis of her receipt of benefits, she had been the victim of unlawful discrimination. And she brought the claim in person. I think there was some sort of help from lawyers sort of behind the scenes, but she certainly wasn't formally represented. And she secured damages and an admission of discrimination, which is a really fantastic result on, quite a sort of cutting edge area of law. So it's just really very impressive. And then the case of Jane and letting agent was the first case in which the court made some sort of pronouncement or ruling in respect of no DSS policies. What happened in that case is that it was brought by a lady known as Jane, a disabled single mother. She was looking for accommodation after her landlord said that he wanted the property back. She was renting in the private rented sector. She saw an advert for what looked like a suitable property and sent a message to the agent and received a response. She said in her message, that she works part-time and receives some housing benefit. She received a response saying, unfortunately, we don't accept housing benefit, so we couldn't proceed with a let on this basis. And when she said why, she got a response saying, this isn't being done on rather than being done on an ad hoc basis, we've had a policy for many years not to accept housing benefit. So after that transpired, and after some free action correspondence, Jane brought a claim county court, and eventually it was disposed of by consent, with the defendant agreeing to a declaration being made without a trial and paying damages and costs. And the declaration was that the defendant's former policy, because the defendant had dropped it after the proceedings started, the former policy of rejecting tenancy applications because the applicant is in receipt of housing benefit was unlawfully indirectly discriminatory on the grounds of sex and disability, contrary to sections 19 and 29 of the Equality Act. And it's significant because it's the first sort of judicial pronouncement on the topic that we're aware of. It was, as I said, made by consent. It was made by a district judge, so it's not binding authority. But making of a declaration is an exercise of the court's discretion. It's not something the court has to do, even if the parties agree to it, and therefore it's not something that the court would or should do if not satisfied that it's right to do so. So it does have some force. Turning then to the case of Stephen Tyler and Paul Carr Estate Agents. This case is significant because it's the first one, and so far the only one that we're aware of that has gone to trial. So Mr. Tyler was a gentleman with mental and physical disabilities. He used a wheelchair. He was married with, by the time of trial, he had 4 children. And he became homeless after he had to leave his accommodation because the landlord had refused to make disability accessible adaptations. He was homeless for over 6 months and spent a lot of that time sleeping in a car. And he was repeatedly applying for accommodation and being knocked back because essentially he is in receipt of benefits. On the 7th of September 2018, he called the defendant in this case, and his case was he asked about 3 properties that were advertised as being to let, and was told that none of them accepted benefits, and that it was company policy that we do not accept DSS. There was then an exchange of messages on Facebook where the defendant gave a somewhat nuanced response saying we can consider applications from applicants in receipt of housing benefit provided the affordability threshold as determined by the referencing provider is met. Unfortunately, housing benefit is not considered as part of the household's income for referencing purposes. However, many other DW payments are accepted. And then there was some pre-action correspondence, and it resulted in a claim being issued. That claim came to trial on the 8th of September 2020 in front of Her Honour Judge Stacey, now Mrs Justice Stacey, who sat with an assessor pursuant to section 114 of the Equality Act. And the case kind of began by being defended on all fronts, really. It was denied that there was any telephone call, or if there was a telephone call, it was denied that it was as described by the claimant. It was denied that there was a PCP. It was said that the PCP, it was denied that that PCP, if it existed, would put disabled people at a disadvantage. If it did, then it was denied it was justified. But actually, sort of as the case wore on, and particularly throughout the course of the trial, and a number of those issues kind of crumbled away, and it came down really to, was the claimant telling the truth about the phone call? And the judge found that, in essence, his evidence of the phone call was correct, and that he had been rejected in respect of those three properties because of his receipt of housing benefit, and that the criteria at section 19.2 were met. So that was a policy which amounted to a PCP. It was a neutral application. It put disabled people at a particular disadvantage, put the claimant at that disadvantage, and the defendant hadn't shown that it was a proportionate means of achieving a legitimate aim. A few points to note about this. So firstly, it was a case where the existence of an ODSS policy was denied, and it wasn't a case where there was, as in the Jane case that I've mentioned, an email saying, oh, we've got a long-standing policy not to accept housing benefit. So the facts were not sort of as clearly written out as in some other cases. The claimant, as I've just shown, still succeeded. The judge made a declaration, as I'll come on to, not in respect of all of the properties which the defendant had on its books, but just the three that he inquired about, which I think is relevant because it shows that there doesn't need to be some company-wide policy. The question is, was this applicant rejected for this property purely because of benefits? And then, as I said, there was a declaration made. That declaration was that the defendant unlawfully indirectly discriminated against the claimant by applying to him the provision and criterion of practice of refusing to consider applicants in receipt of housing benefit for three private rented properties that were being marketed by the defendant. An award of damages was made of £6,000 plus interests, and costs were awarded on the indemnity basis, on the basis that the case sort of shouldn't have been defended. It couldn't have succeeded. It's, you know, a reasonably sizable amount of damages for discrimination cases, and in part it marked the disapproval of the way that the case had been conducted, but it was also recognised as being a sort of a serious matter which had really kind of resulted in injury to the claimant's feelings. So that was the case that went to trial. Since then, there's been one other case resulting in sort of judicial intervention, if I can put it that way. This was a case brought against William Manor Estate Agents. The claimant in that case was given a Section 21 notice, so began looking for accommodation, saw an advert for one of the defendant's properties, was sent an inquiry and received an email saying the landlord's ideally looking for professional tenants, no pets, no children, and no benefits. When the claimant queried that, she received a response reiterating that the landlord didn't accept benefits. So the claimant filed a claim and received an admission from the defendant, who didn't defend it. There was then some toing and froing, but it eventually resulted in an order made by consent, which declared that the defendant had unlawfully and directly discriminated against the claimant on the ground of sex, and also an agreed sum of £3,500 in costs. There have been a few other no DSS cases. One of them is Rosie Keogh, which I've mentioned, Emma Loeffler and Amanda Staples, which also received some news coverage. And in addition to that, there have been, 3 other cases, which I don't think have been kind of reported in the media, but all settled with damages and costs, and all contained some sort of admission or acknowledgement that these policies are not right. So there's been, as we've seen, a succession of cases brought so far, and those are the results that we are looking at so far. And in terms of a few sort of final observations, firstly, huge credit is due to Shelter and to Shelter's clients, who have really been persistent in tackling this issue and have made some enormous strides. I'm going to pay a very mixed tribute to the LAA. It has been a battle to get funding, and I think a lot of people on this Zoom will know what that entails. But funding has been obtained, and it would be very difficult, if not impossible, to bring the cases without legal aid funding. And it shows really how important legal aid is, and how much we need to defend it if we can against further encroachment. And then finally, hopefully there is some sort of message of hope in this, in that I think a lot of us saw no DSS policies as an immovable feature of the landscape. It always was and always shall be. But actually, we can see here that the Equality Act has real teeth and can be used in correct circumstances to achieve some really positive changes. So that's the use of the Equality Act in some cases involving private rented sector issues. And I think Ed now is going to talk about the Equality Act and homelessness.
That's brilliant. Thank you, Tessa. It's great that would have been a very different talk if you'd given it this time last year. There's been real progress in this area, and well done to everyone involved. Before we move on to Ed, would you mind, there's a question in the comments from Nick Antonides that says, as to legal aid, was funding obtained but not in relation to the claim for damages? Would it be possible to answer that now before we move on?
So there's been a variety, I'm not totally sure that I can give a very clear answer in respect of each kind of way in which it's been funded. The funding, I don't recall having a limitation in respect of damages, but would need to check. It's a good question, and I can't give a very clear answer, so I better not give much of an answer at all. Sorry, Nick.
No, not at all, thanks. Can I pass over to Ed?
Sure. So, I'm going to talk about the Equality Act in homelessness appeals, and there's some crossover between the analysis Tessa did of the Equality Act, and I just do pay tribute to the remarkable work that Shelter and Tessa have done. And some of the responses and some of the cases, a lot of which seem to settle, are quite extraordinary, where people deny having ever said that we won't accept you because you're on benefits, etc. And then have to back down very quickly when confronted with the case going to trial. But it is remarkable work, and gathering all the statistical evidence has been really important as well. But what I'm going to talk about is the application, some of the recent cases to do the application of the Section 149 of the Act. And generally, we're talking about subsection 3, the need to remove, minimise disadvantage suffered by persons who share relevant protected characteristics. So we're all quite familiar with it. And again, Tessa's touched on it, protected characteristics under Section 4. The main ones we tend to deal with are disability in particular. And there's definitions for a number of the protected characteristics. It's interesting, part of the talk I'll come on to in relation to gender reassignment, which is actually defined under Section 7, but there's a very limited definition there, which I think will have to be expanded, having regard to some of the recent cases before the European Court of Human Rights. It seems to me the definition under Section 7 is a very limited one. So The case that, in a sense, started the ball rolling about the application of Section 149, it actually came under the Disability Discrimination Act, and it's still, in my view, an important case, Peretti, because that was the first time that the court recognised the application of the application in housing cases of discrimination legislation. And in that case, it involved the local authority had found that the applicants had made themselves intentionally homeless. They hadn't paid the rent. But the argument raised was that they hadn't made sufficient inquiry in relation to mental health issues, which had been put forward in a very limited way. And what I've set out there is the determination of the court, and it's the last paragraph. The question was, did they fail to make further inquiry in relation to some such feature of the evidence presented as raised a real possibility that the appellant was disabled in a sense relevant to whether he acted deliberately? So in reaching that conclusion, it was found that the usual approach in Cramp and Hastings didn't apply, and that's the approach that inquiries, it's only where you can say that no reasonable authority would have made the inquiry that you can challenge the decision. In that case, it was found that that's disapplied when discrimination issues come into play, and it was found in that case that there was a real possibility that the rent arrears had arose because of mental protected characteristics, and in that particular case, it was to do with mental impairment. And the approach taken still applies. There's a fairly low threshold to putting them on inquiry as to issues arising in terms of protected characteristics. And I think coming on to some of the later cases, that's important to note and underscore. We're all familiar with the seminal judgment of Lord Neuberger in Hotek. But again, what I would highlight is the fact that it's set out there that the reviewing officer has to focus. There's a sharp focus on whether the applicant is under a disability or other protected characteristic, and then the extent of the disability and the likely effect of the disability with any other features if and when homeless. So there has to be that focus. And as I say, there's a suggestion in some later cases that it's a question of fact as to whether or not someone is disabled, but in applying Section 149, there is a requirement to consider with a sharp focus whether or not someone is under a disability and how that affects the particular issue arising in that homelessness case. And we're all familiar again with the case of Hack and Hackney. And that was a case where at first instance, it was all to do with suitability of accommodation, hostel accommodation, with regard to the applicant's disability. And in fact, it's fairly striking that if one looks at the judgment, all the issues that were raised had been considered with fairly anxious scrutiny, it has to be said, all the different aspects raised in terms of saying why the property was unsuitable. And in fact, the judge at first instance, His Honour Judge Luba, effectively threw out all the arguments to say that proper account hadn't been taken of this or that. But in relation to Section 149, his determination was that, in fact, the passage from Hotek had been cited. I think the expression used was that the reviewing officer had gone to the well but hadn't drunk from the well. But Lord Justice Briggs disagreed, reiterating that it's particular to priority need, if the reviewing officer has done a proper job assessing in terms of functionality, priority need, but in this case to do with if the reviewing officer has assessed all aspects of suitability, then they may not even need to refer to the Equality Act. But again, we've got, he does give very helpful guidance at paragraph 43. So there's got to be a recognition, and it was accepted that Mr. Hack was disabled, and then one has to look at a specific focus, or a focus on specific aspects of the impairment, consequences of the impairment, and then one looks at the particular needs in relation to the accommodation that's been offered. And in terms of that case, a recognition of his particular needs arising from the impairments and the fact that you might have to treat him more favourably in the provision of accommodation. And there had to be a review as to suitability of this room in the hostel, having regard to these matters. And of course, the analysis was that all that had been done, and therefore there was no challenge. Another successful case was a case of Lomax and Gosport, and again that comes into a different category. The argument there was that the appellant was arguing that he was homeless, as it was not reasonable to occupy accommodation in Dorset, and he'd moved and made an application to Gosport. And again, it was a successful appeal, and Lord Justice Lewison found that was in agreement with the representations made to say that in performing a comparative exercise between Miss Lomax's particular needs and disabilities on the one hand and general housing conditions in Gosport, effectively to say the housing situation in Gosport is really bad and you won't get much better than you had, there was a serious danger that the sharp focus became blunted. Then we have the case of Cannon and Newham, and again, this was to do with whether or not long-term temporary accommodation was in fact suitable for Mr. Cannon, and it was a case where, in fact, there was he had to climb 14 external steps to get into the premises, and his description, which appeared to have been accepted, was that he suffered from severe pain on each occasion he climbed the stairs. And in relation to his situation, there was medical evidence that effectively found the same, set out the extent of his disability. The reviewing officer appeared to accept that, but then later on referred to his pain being uncomfortable and inconvenient. And again, Lord Justice Lewison, adopting the approach in Lomax, said that the local authority weren't entitled to regard to general housing conditions, and as in Lomax, found that the decision of the reviewing officer, the fact that it referred to the guidance in HOTAC, as most review decisions do, and he set out that the mere recitation of Lord Neuberger's formula was no substitute for actually doing the job. So in this case, where there was evidence, medical evidence, and evidence from the applicant himself, which was not challenged on review, it wasn't said that actually you're exaggerating it. It was a situation where it was accepted that every time he climbed those stairs, and he'd been in the property by the time of the review for some 15 months, he experienced severe pain. The court held that there hadn't been a proper regard to the Equality Act, the Public Sector Equality duty, and moreover, that there was a failure to take into account his medical condition, particularly where he was in this accommodation for such a period. We then have a case that McMahon and Kiefer, and that was a case, and it is now, and I raise it in some detail because it's now a case that's cited quite a lot in terms of, not surprisingly, in terms of reviewing officers' decisions and skeleton arguments, and it's worth putting it into some context. because in that case, just dealing in a thumbnail sketch with the facts, Mr. McMahon had suffered back, neck, shoulder, and arm pain, but it was in the actual review decision by Mr. Purdius, who I think joins us this evening. There was quite a detailed analysis of how that affected his functioning, and both these cases were priority need cases. In terms of Mr. McMahon, there was no actual finding that he was disabled in the review decision. The review decision was quashed on appeal for a failure to properly take into account the Section 149 duty. And likewise, in relation to Mr. Kiefer, again, the extent of what was raised was fairly limited. He suffered wrist pain, type 2 diabetes, but it was controlled. And he had to wear special wristbands, etc. Now, in his case, there was in fact a finding that he wasn't disabled, that he didn't meet the relevant criteria under Section 6, and there wasn't substantial interference with day-to-day activities. And in relation to both cases, on appeal, the decisions were overturned and rejected by the Court of Appeal that there was any proper arguments in relation to failure to apply the Public Sector Equality Act duty. But Lord Justice Lewison used that as used the case to review, as he sometimes does, what had come before, and I think it is. As we are now finding in cases that a lot of what he said in McMahon and Kiefer is being raised, it's important that we're in a position to address it. And what's reiterated, and I think this does apply in particular priority need cases, what he reiterates is the fact that, again, we all know that Lord Newber said that the PSED, Public Sector Equality Duty, was complementary. And in relation to a number of cases, it may have been met without actually referring to Section 149, or in fact explicitly referring to the duty, or explicitly, presumably, making any finding as to whether someone's in fact disabled. And so sets that out. Also goes on to highlight that the relevant function in the case was to determine whether the applicant in question was vulnerable. In addition, many cases emphasised the duty is not to achieve a specific result, but a duty to have regard to achieve the goals identified. And again, I think we're seeing in some of the possession cases, this has been highlighted in a number of the more recent authorities. It's not to achieve a specific result. Furthermore, it sets out that it applies at the investigation and reporting stages of the review. And again, referring back to Peretti, identifies that in that case, the flaw was the failure to undertake sufficient inquiries in terms of the applicant's mental health problem. And I think if one reads McMahon and Kiefer, there can be no question that there was a very thorough job done in looking at these conditions and the way they affected the individuals day to day, and the way they are likely to affect them if without accommodation. And also highlights the fact that, again, HOTAC doesn't lay down a sequential test. I mean, I would have thought it may do, because it was logical to take those factors in order, but it said that what needs to be considered in the assessment of vulnerability is that which is relevant to the person's ability to deal with the consequences of being homeless. And we know that it's a practical assessment as to vulnerability, priority need, in that context. So then, and then again, just some further points highlighted. There's quite a long list of points that he made in the case. it sets out that what matters is the substance of the assessment and not its form. So you look in substance as the way the case has been assessed in a practical, contextual manner. And again, sets out, just as a failure to mention the PSED or a failure to tabulate each feature of it will not necessarily vitiate the vulnerability assessment. Again, he refers to his case of Cannon, that the mere recitation of the duty will not be enough if you failed in substance to address the relevant questions to be asked. And then goes on to refer to the fact that, as we know, under Section 4, some categories of persons are entitled to automatic priority, but the disabled are not, only entitled to priority if the disability causes them to be vulnerable. If they're not vulnerable despite having a disability, then a decision that they do not have priority need is simply putting Parliament's decision into effect. And finally, and I think this is quite important, when we're being referred to this case and the effect of it, he sets out that one of the most striking features of both appeals is there's no evidence that any of the medical conditions has a real effect on the ability of either of them to carry out normal day-to-day activities. And I think if one reads the judgment through, and it's fairly lengthy, this type of case, I mean, that comes across that in terms of normal day-to-day activities, there was nothing of great significance that one could sort of highlight or put forward. And finally, he sets out that the danger of using PSED as a peg in which to hang a highly technical argument that would otherwise it'd be an unimpeachable vulnerability decision and assessment. And I think, in particular with regard to vulnerability, there is this: if one's got a case where that has been looked at in great detail in regard to the medical evidence functioning, it'd be quite surprising if you had a freestanding argument as to the public sector equality duty. Then we come to a case that is troubling in some respects, and is also going. Nick, who may say something about it, Nick and Liz Davies. There is an application before the Supreme Court for permission to appeal, and in that case, it involved the offer of accommodation and the refusal of the offer, and as is set out, it was said that there was a short, inflexible time given to the applicant to accept the offer, and I think it's right to say that some of the arguments were developed along the way, but in terms of it, there was arguments, specific arguments that there was a breach of Section 19 and Section 15 of the Equality Act, and it was sought to, and it's a lecture in itself, but it was sought to bring that into the homelessness appeal, and that was rejected at first instance again by His Honour Judge Luba, and then it came before the Court of Appeal, and again the leading judgment was given by Lord Justice Bean. I think a learned Judge Bean is not right. Lord Justice Bean gave the leading judgment, but on the panel was Lord Justice Lewison, and what has been highlighted in cases that we now have is what he says at paragraph 18. He refers to grounds 1 and 2 and says raised issues to do with disability, which fell within the exclusive jurisdiction of the County Court. And those grounds were the grounds in relation to Section 19 and Section 15. But he sets out the most important of these was whether or not the appellant was disabled. Cannot accept Miss Davies' submissions that this was an issue of law. The statutory definition of disability is is a question of law, but whether the appellant fell within it depended on findings of fact, followed by an evaluative judgment as to whether those facts fitted the statutory definition. So what has been said I think there's a tendency now that some reviewing officers, local authorities are saying, well, it's much easier if you just say, well, you're not disabled, rather than say, well, you may be disabled, but we've taken it all into account and we assess that you're not entitled to more favourable treatment. So it may be said, well, you're actually not disabled, and if you want to challenge that, you have to make your challenge. You can't make it on a Section 204 appeal. You've got to make it in the county court, or sorry, a separate application for a declaration in the county court, giving rise to what would likely be quite a cumbersome litigation, where you'd have to bring a Section 204 appeal, a separate county court claim, and try and marry them up at some point. So one can see great difficulty in that. But if one stands back from that situation, I do think that, and it's interesting, Lord Justice Lewison didn't say that, it would have been quite easy for him to say in McMahon and Kiefer, well, actually, you can't. There should never have been any challenge in relation to whether or not someone's disabled, because it's a question of fact. He didn't do that. And all the guidance that comes before, which I've set out in summary form, still applies. So you've got to have due regard, sharp focus as to whether someone's disabled. Now, I suppose if a reviewing officer has taken into account all the medical evidence, all the aspects of functionality to do with an applicant, and nonetheless made a finding of fact that they're not disabled, well, then that's when you might have this jurisdictional problem. Generally speaking, challenges that we have it's because aspects of the case haven't been considered with that sharp focus. So I don't think it's as binary as it may appear in that paragraph 18 of the judgment. And as I say, some local authorities are going in the direction to say, well, you can't challenge it in a 204. A case that was, recent case that was helpful, reported in legal action, case of HM, the client, 66 years old, number of health conditions, including vascular dementia. But one of the issues was it was an offer of temporary accommodation in Croydon with 25 to 30 steps. And in considering the whether or not there was compliance with the duty, His Honour Judge Johns found that the findings made that access to the property was not impossible, and that HM could limit the way in which he came and went from the property by using video and telephone calls, suggested a lack of the sharp focus. And that's the sort of situation where I think, quite rightly, there is impact from Section 149, because they can't get away with generalities about, well, we think you'll be able to do all right in these circumstances. Your family can visit you and provide support. You can go on Zoom. You don't need to go out that much. As His Honour Judge Johns identifies, there must be the requisite sharp focus, and also find out in particular did not show an awareness of the need, to take steps to meet HM needs, which might require more favourable treatment than might be given to an ordinary homeless person. So just in terms of where we're at, just listed some of the points to bear in mind. First of all, by reference to canon, it's important to align the arguments as to the substantive with the PSED arguments, whether arguing in relation to vulnerability, suitability, intentionality, or whether you're in fact homeless. And it's unlikely that the duty will result in a freestanding argument on vulnerability. And again, I've highlighted that the Court of Appeal has demonstrated how there will be, where there's close scrutiny of the facts, well, first of all, there is the cases that we've referred to do involve close scrutiny being applied, to the decision-making process in relation to all aspects that could come within the purview of Section 149. And then in terms of technical arguments and arguments or overzealous linguistic analysis are not likely to succeed. And then finally, in terms of a number of these cases, it is important where decisions are made as to, or suggested in the minded to letter, that those are addressed in detail. If not, it gives the reviewing officer and certainly a way out in terms of saying, well, if it was something of importance that had to be considered or weighed into the balance, you ought to have addressed it. And just in terms of further issues arising in this, with regard to the application of the duty, I had a very interesting discussion with Shannon Roberts at Hodge Jones and Allen about some of her cases. She deals with a lot of cases to do with extremely vulnerable applicants. And one practical thing she was saying was that in their cases, what they often do is at the start of the case where there's very sensitive material going before the court, and one can see applicants being very reluctant to share a lot of personal information reports, that they would make an application at the very start of the case, along with the grounds of appeal, for an anonymity order. And obviously that involves balancing of the interests of the individual and also the interest in terms of open justice. And there is, I've cited the case of XXX where that was very recently considered by the Court of Appeal. But as I understand it, the practice and some judges are prepared to grant the order on the papers. Other judges will list it for a preliminary hearing, but I can see that in terms of promoting the interests of the clients, that is can be a very good thing to consider at the start of the case, rather than just when you're coming up to the substantive appeal hearing, and could provide some great reassurance. Another point that Shannon was raising, and it was in particular to do with a case involving an applicant who's gender fluid, was a problem with Westminster, where their actual application forms had only, in terms of title, had only male or female. They didn't even have other, and it resulted in a problem that their client didn't, in fact, get across parts of her case in terms of vulnerability, and it was only later on that they became aware of that and sort of complained that these issues hadn't been raised. And as a result, as I understand, I think Westminster are changing the forms. And also what arose was when they had to apply for an interim injunction, because there was a problem with temporary accommodation. There was also issues before the court as to the proper pronouns to be used and the proper title address in relation to their client. And I think they had a very a judge in the High Court who was very tuned into it, and because they set out in the first paragraph of their statement how their client wanted to be addressed, that was dealt with in a very sensitive way. I do recall, being an oldie, that when the term Ms. was first introduced, I used it in case, and I got shouted at by a judge. He said it's Miss or Mrs. Mr. Fitzpatrick. Don't be so silly. So MX, it may be a surprise to some judges, but I think helping the court and even the other side with setting that out, it can be very helpful. And another case, and the third bullet point that Shannon reminded me of, in fact, involved our very own John Beckley, now distinguished judge. And it sort of highlights some of the problems arising in relation to gender assignment, where their client was in the process of transitioning, and there arose huge issues to do with temporary accommodation, whether they were going to be put in all male or all female accommodation. And I think, again, they reached the door of the court before finally they were, in fact, provided with self-contained accommodation. But I think in the likelihood is these issues, well, we know these issues are arising more frequently, and one can see where someone is perhaps gender fluid, one can see in terms of priority need, could suffer discrimination, or if on the streets, as it were, and also one's got the issue as to temporary accommodation and how that is properly sourced. Final point, and just to flag up, is the James and Hertzmayer, the Court of Appeal case that, again, Nick was involved in. It finally determines this question to say that policy matters can be dealt with in a Section 204 appeal, but says that you may want to, in certain cases, transfer the case to the High Court, relying on the general provision to do so under Section 42 of the County Courts Act, also in the CPR 30.3. And there is a discretion to transfer, and that was tested in, not tested, but in a recent case of Bancole and Jones. It wasn't to do so much with a policy challenge. It was a test case to do with the applicant being whether or not the applicant was in priority need, and part of the argument was to say that the COVID crisis presented an emergency. But the court was persuaded, the county court was persuaded to transfer it to High Court, and then belatedly there was an argument to say, well, you shouldn't have transferred it. But the judge says no, it was appropriate exercise of the discretion. So I think we may find that in some cases we're looking at transferring cases to the High Court, especially if there's particular points of public interest or policy in doing so. And so that's the end of my talk, and hopefully we can persuade maybe Shannon to say a couple of words about the cases of hers I referred to.
That's great, thanks, Ed. And I can see a message from Shannon in the chat that says, my tip is to set this out in the beginning of the review request, if necessary, or the pleadings, i.e. mix and then initials instead of names, and setting out the pronouns that don't identify the litigant by gender. Unless Shannon wants to add anything on that, I'm sure we can enable that. We've got a little time for questions, and what I'm proposing them to do is put them three at a time until we run out of time, and ask the panelists to come back in turn. So starting with a very interesting question from Simon Mullings, who says it's about property guardians. He says property guardians routinely stipulate that guardians must be employed before they will be considered for a license or a letting. At the same time, guardian fees or rents are well within local housing allowance levels. Are there potential discrimination claims in this context? The next question hinges off something Ed said right at the very end there about policy challenges in Section 204s. And it's a strategy question because you mentioned transferring it to the High Court. Is there an argument for keeping it in the County Court? Because as a remedy, it's quite exciting and fun. And a circuit judge or recorder might find themselves sympathetic to that sort of interesting remedy, whereas it's a bit more run of the mill for a High Court judge. And the third question is, as difficult as these no DSS cases are, is there any scope for urgent interim injunctions where a landlord or an agent is refusing to let, particularly on the strength of the recent shelter case? You're both welcome to tackle those, but can I ask Tessa to come in first, please?
Sure, thank you very much for those questions. So in relation to the first one, the term in property guardian contract saying that you have to be employed, potentially, yeah. I mean, whenever you have a blanket rule, it's worth looking at it and seeing whether it is discriminatory. Obviously, being employed isn't coterminous with being in receipt of benefits, because lots of people are employed and receive benefits. So I can't sort of say that I have the statistical knowledge to say whether or not it is discriminatory. But it would be worth looking at whether a rule like that impacts disproportionately on a particular group, such as perhaps people with disabilities. And if it does, then they would have to be justified in order to be lawful. In relation to the third question, any scope for an interim injunction, that's a really interesting question, which it's not something I've sort of got a considered answer to. But my sort of provisional thoughts would be, it might be tricky, because what would be the relief? Would it be that I don't think you could get relief sort of to compel someone to let. So the relief might be that you can't let the property, to stop them letting the property to someone else, which I think would be difficult. It's worth considering, but I sort of see obstacles in the way, is how I would put it.
And then Ed, did you want to come in as well?
Yeah, not on those two questions. No. To do with the, Hertzmere, the review by the Court of Appeal, which Nick, you're very familiar with. My reading of it is effectively, yes, you could just deal with it in the county court, but I think if we were challenging, say, a local authority's out of borough placement policy, and the root and branch, etc., it is more. I would be more comfortable trying to do it by way of, obviously, I think a transfer to the High Court might be beneficial, because the High Court judges are much more used to dealing with that sort of policy challenges and that sort of analysis. But and you might be criticised for not doing that if it was a big case in terms of a big policy challenge. But the discretion is there. It is suggested that it's going to be exercised, that you'd only go to the High Court in quite limited circumstances, although Bancole didn't necessarily seem to fit that bracket. And also, it would have to be something that involves sort of wider public importance to an extent. But yeah, I think you'd have to just make a judgment call in the particular case.
Thanks. And I think the local authority tried unsuccessfully to argue in Bancole Jones that it couldn't be done. But of course, we now know that it can, which is helpful. I've got three more questions. The first one is from David, and it says, and I guess it's addressed to Ed, how does transfer to the High Court enable further arguments to be made? Does the case cease to be a 204 and become something else?
No.
The next question is the participant asks that their understanding, based on what Tessa said, is that a claim pursuant to the PCP provisions does not require the claimant to have the protected characteristic, and provided that they can point to statistical evidence. Is that correct? And then the third, which are combined, are there any transcripts or records of the no DSS judgment? And is Shelter's statistical evidence of how people with protected characteristics are more likely to be in receipt of housing benefit publicly available? So Tessa, do you want to come in on those?
Sure. So firstly, can you bring a claim even if the claimant doesn't have the protected characteristic? The answer to that is no, because Section 19(2) says that in order to have an indirect discrimination claim, you have to have a PCP which is discriminatory in relation to a relevant protected characteristic of B, of the person. So B has to have the protected characteristic. And of course, it goes on to say that the question is, does it put people who share that characteristic at a disadvantage compared to people who don't share the characteristic? So indirect discrimination is predicated on someone having a protected characteristic. Having said that, I appreciate this wasn't actually the question asked, but it was something that's been put to me before. And I think it's quite an interesting question. Is it, well, can you then have a no DSS policy but not apply it to men, or not apply it to non-disabled people? There are two difficulties with that. One is that if you have a policy which applies only to men, then you may find yourself facing a direct discrimination claim. And the other is that you don't generally know, when you're dealing with an applicant for a tenancy, every facet of their makeup in terms of what protected characteristics they have. So if you're talking to someone over the phone, you're unlikely to know whether or not they're disabled, and therefore you might have practical difficulties in applying a policy to them. Second question about transcripts and the evidence. So in relation to transcripts, the order in the case of Jane is, I think, on the Nearly Legal website, and that contains a reasonably detailed statement of reasons. We don't yet have a transcript in the Tyler case, but it has been requested. And is the shelter evidence available? I don't know. It's worth looking on their website to see what's there. But as I said, the Jane case has a reasonably detailed statement of reasons, which sets out some of the relevant statistical evidence that I've talked about in more detail than I've gone into this evening.
Yeah, just to do. I mean, in terms of the actual, if you apply for a transfer under Section 42, the hearing, yeah, it would take effect as a Section 204. The case of Bankole Jones, it's just a Section 204 that's heard before a High Court judge. But I mean, I think in terms of it, and I can certainly see the attraction, and particularly if you get a listing in front of a judge you don't really like, to go along and say, well, I'd actually like to transfer this to the High Court. I think one thing to observe in terms of Bankole Jones, because it's not a big policy challenge, etc., is the fact that the application was made, accepted, and the query as to it was only raised on the day of the hearing, and the judge wasn't very impressed with that. He said, well, you didn't appeal the decision, you just come in here and moaning at me today. So yeah, I think yeah, it does take effect as a 204 appeal just before a High Court judge. I think in that case, it's right that they were asking for some guidance that would have been of wider importance to do with COVID cases and whether it had created an emergency. And I think they also asked for guidance in terms of the application of the transfer provisions, and the judge said, no, I'm not giving you any.
That's great. Thanks, Ed. I think we are just about out of time with that. So thank you both to our speakers this evening, who've been excellent, and to you for your intelligent questions. And we look forward to seeing you at our next event on the 6th of March, if not before. Thanks very much and have a nice evening.